Hello everyone, I am going to talk on the topic today is dying declaration, which is contained in the section 32 of the Indian Evidence Act 1872. Among many medical fraternity, the concept of dying declaration is not that clear. I try to explain this topic with some of the case laws. Look at the principle of latam mortem, which means the word said before death. In legal term, it is called as a dying declaration when it is extrapolated to the cause of death. The cause of death. That means dying declaration in the literal meaning, it said that a statement made in written or verbal pertaining to the cause of or any circumstances of transaction of his or her death. So, in the nutshell, the Indian judiciary system recognizes the fact that a dying man seldom lies or the truth sits upon the lips of a dying man. So, judiciary trusts it. So, it is an exception to the principle of excluding hearsay evidence. Look at this case, P.V. Radhakrishna versus State of Karnataka. In this case, the court held that the principles on which it is admitted as evidence is based on the maxim, that is a Latin maxim, Nemo Mauritius Presumpta Mentri. That is, a man will not meet his maker with a lie on his mouth. Information lodged by a person who died subsequently relating to the his death is admitted in the court of law as an important piece of evidence. This is an important case explaining the circumstances of transaction, Ukaram versus State of Rajasthan, wherein a couple had picked up a quarrel at home and all of a sudden there was a huge cry heard by a neighbor. When a neighbor rushed to the spot, he could see a woman sitting burning with a torn cloth outside her home and short while her husband ran away from home. Woman tells to the neighbor she was doused with the kerosene and set her ablaze. And this piece of important piece of evidence accepted by the court. Yet another case of circumstances of transaction, Pakala Narayana Swami versus King Emperor. In this case, a trunk containing the cut pieces of human body was recovered in a railway compartment. Just prior 2 days to that, the victim had told his wife that he is going to accuse home to recover his loan on his invitation. So, so this important piece of evidence is considered by the court and accepted as a very important piece of evidence. So forms of dying declaration. It can be in the question answer form where the questions are put to the victim and the answers are elicited as it is. The dying declaration can be in a gesture and sign form. Look at this famous Queen Empress versus Abdullah. Here the 17-year-old young girl neck was slit and she was unable to speak. And with the help of her hands, she was able to make signs of the name of the accused. And with this piece of information, the Allahabad High Court accepted as an important piece of evidence, and the accused was convicted for malicious. The language is not a bar. The declarant can make the declaration in any language as long as the interpreter and the person who is noting down they they don't alter the meaning of the declaration. Even incomplete statement, if the declarant has stated major chunk of the statement, only little thing is left, still that can be considered as a valid piece of evidence by the court. In case where a declarer survives, still it is acts as an important piece of corroborative evidence wherein the declarant will be summoned by the court to testify. Look at this case, Akbir versus Government of NCT of Delhi 2010, where the eyewitness has told that the declarant was fit, so that's enough. The court considers there is no need of medical certificate required to testify compost mentis of the person. So FIR has a dying declaration. So look at this case, Ramachandra Reddy was a public prosecutor 1976. It was held that where an injured person lodged a FIR and then died, it was considered FIR itself as a dying. Look at this, the medical report as a dying declaration. Here in this, the doctor had entered some of the details of the patient in the accident register kept in the emergency department regarding his vitals and brief history. And the person dies before making a dying declaration. So the details entered in the accident register itself is considered as a dying doctor statement as a dying declaration. Here, when the patient was taken to the doctor, In front of the doctor, she admits that her husband doused her with kerosene and set her on a blaze. And the same thing was entered in the case records. The details of the case records were taken as a dying declaration, and the doctor was called to give a witness. Whether statement made to the implicating relatives is acceptable? Yes. The apex court has laid down in the Bharati versus State of UP. So here, if there are nobody around the person who is about to die, and the declaration made by him to the near and dear ones can also be considered and corroborated and sometimes taken as an important piece of evidence. How proximal the dying declaration should be. There is no as such time limit or duration stipulated or defined by the courts or in any law. So, in one famous case that Sharda versus State of Maharashtra, a newlywed lady, she kept on writing letters to the parents and relatives regarding the torture meted out to her in her in-laws' house. The letters, which were over the period of 4 months, were considered as dying declarations, and that was taken as an important piece of evidence. If there are more than one dying declaration, the court should read as one and try to reconcile, and the same meaning should be try to take the same meaning in the both. The evidential value of the dying declaration in K. R. Reddy versus Public Prosecutor, the evidential value of dying declaration was observed as under. Once the court is satisfied that dying declaration is true and voluntary, it can be sufficient to found the conviction even without the corroboration. Apex Court laid down the following guidelines as related to the dying declaration in Kushal Rao versus State of Bombay AIR. 1. The true and voluntary declaration needs no corroboration. A dying declaration is not a weaker kind of evidence than any other piece of evidence. Each case must be determined on its own merits and facts. Very, very, very important. The fourth point is the dying declaration stands on the same footing as the other piece of evidence. Only thing it is judged in the light of the circumstantial evidences with respect to the principles governing the weight of the evidence. The fifth point is if the due process authentication is established, it stands on a much higher footing than the oral testimony. The Supreme Court of India has established the board principles of dying declaration in the decision of Adbir versus Government of NCT Delhi. If the court has full faith in dying declaration, it can be used as a sole basis of conviction. The court must be convinced that declarant was mentally stable while making the statement and that it was not the repercussion of tutoring or prodding or imagination. If the court is convinced that the declaration is true and voluntary, it can convict without the need for further corroboration. The fourth point of broad principles is a dying declaration cannot be rejected or dismissed simply because it is short. On contrary, briefness ensures its accuracy. There is no rule of law saying cannot be acted upon unless it is corroborated. A dying declaration should not be dismissed just because it lacks specific information about the event. Seventh point of the broad principle is if founded no effort to induce the declarant to make an untruthful statement and if it is coherent and consistent, no corroboration required. The mental stability versus eyewitness. There is no mental stability certificate from the doctor is required all the time. If the eyewitness says he was fit, he is sufficient to consider. Ninth point is if appears suspicious, it should not be followed up on without corroborative evidence. In conclusion, Lord Ire C.B. held that the principles on which this evidence is admitted is that they are declarations made in extremity, when every hope of this world is gone, when every motive of falsehood is silenced, and the mind is induced to speak the truth. A situation so solemn and awful is considered by the law as creating an obligation equal to the oath administered in the court of law or in the court of justice. These are my references. Thank you, one and all.